Good day, Crime Talk aficionados. We have a big show to take you into the weekend. First, new facts are leaking out in the Bryan Kohberger matter. A botched execution in South Carolina. Hey, you're not entitled to a perfectly painless execution. An example of just letting it go. It's just a car. A unique weapon used in an attack in Arkansas. The former Supreme Court Justice Anthony Souter passes away. The state responds to Lori Vallow's motions for a new trial, this day in legal history, and our dumb criminal of the day. Let's talk about it.
All right, lawyer.
Good day, everyone. My name is Scott Reich, and this is Crime Talk. Thanks for joining us. You know the drill. Subscribe if you haven't, like if you do, leave me a comment below, hit that little bell for notifications, and yes, you can check us out on any of your favorite podcasting apps. Now, before we get started, let me remind you to go to crimetalksearch.com, sign up for that background subscription service today. When you do, you will be able to prepare a background search on the individual that you are searching for here in the United States. The report is literally prepared while you wait, and you can even get updates if new information changes. And you're going to get in that report, you're going to get all of their phone numbers, emails, social media presence, whether they have divorces in their past, whether they're married, do they have judgments, liens against them, and do they have a criminal history, and are they on one of those registries? You know what I'm talking about. So go to crimetalksearch.com and sign up for that background subscription service today. And remember, you can cancel it at any time. All right, let's go ahead and get to the docket for Friday, May 9th, 2025. And first on the docket, Bryan Kohberger. That's right, new information is being leaked. I'm curious to see where this information is being leaked from. But apparently NBC is going to have their special tonight, so I guess we're all going to find out at the exact same time. But what we do know thus far is that obviously in the weeks leading up to the horrific murders of the 4 University of Idaho students on November 13th of 2022, Bryan Kohberger, the criminology doctoral student at Washington State University, was apparently under some significant stress. As a teaching assistant, Kohberger faced criticism for his harsh grading and demanding demeanor, making students quite uncomfortable. And then colleagues also reported conflicts, prompting the dean to address his professional conduct. Now, amid these challenges, Kohberger's cell phone activity obtained by Dateline, and that's where we're getting this from. We're going to see where they got this because I didn't get it. So I wonder who leaked it. Anyway, this new activity apparently reveals some disturbing patterns by Mr. Kohberger, allegedly. Now, apparently, he viewed dozens of photos of female students from Washington State University, there as well as the University of Idaho, some in bathing suits, with several being friends or followers of the victims, Kaylee Goncalves, Madison Mogen, and Zaina Kernodle. Now, Kohberger, obviously accused of killing all 3 of them, as well as Ethan Chapin, in a rental home near the University of Idaho, had no confirmed prior connection to the victims. However, apparently, some new evidence, including security footage and detailed cell phone data, sheds a little light on his actions before and after the crime. Now, the footage, apparently obtained by Dateline, captures a white 2015 Hyundai Elantra, believed to be Bryan Kohberger's, circling the victim's King Road home multiple times between 3:30 a.m. and 4:20 a.m. on the nights of the murder. Now, this narrows the timeline of the killing, which prosecutors believe occurred between 4:07 a.m. and 4:20 a.m. when the car was seen speeding away. Now, Kohberger's cell phone data, analyzed by the FBI experts, apparently shows that he visited Moscow, Idaho, 23 times over 4 months, often after dark, with his cell phone connection to a cell phone tower within 100 meters of the victim's home. And in late September, he searched for sociopathic traits in college student, followed by a search for pornography with keywords such as drugged and sleeping in October of the same year. And then on October 19th, he searched, can psychopaths behave pro-socially? 6 days before the murders, his phone again pinged near the crime scene. Now, Kohberger's lawyers claim he often took late-night drives for hiking or stargazing, asserting his phone data proves he was not at the crime scene during the killings. And just to be, kind of the devil's advocate and be completely fair here, who knows? Maybe these photos popped up on his phone in some sort of feed of some type. Who knows whether he saved them? The searches could have been related possibly to some research that he was doing. Got to give him the benefit of the doubt, right? Hasn't come out in trial. It's not been found to be legal and competent evidence as of this particular moment. And it is somewhat tenuous to say that those searches led to these alleged killings, or the killings that he allegedly did, I guess, to be more accurate. So anyway, then again on November 12th of 2022, the victims celebrated Senior Day at the University of Idaho, and Gonzalez posted on Instagram carousel captioned, "One lucky girl to be surrounded by these people every day." By 2 a.m., the housemates were home with two others, Dylan Mortensen and Bethany Funk, still awake. Now, between 4:07 and 4:20, prosecutors alleged that Kohberger entered the home, fatally stabbing the four victims with a large knife, a K-bar, in fact. The sheath was found next to Mogen's body, and Mortensen reported seeing a masked figure in black fleeing the scene. Now, sources suggest that Mogensen was the primary target, with Kernodle and Chapin attacked subsequently. Now, Kohberger's phone was off before 3 a.m., but reconnected to a cell phone tower south of Moscow at 4:48 a.m., and he made calls to a number linked to his father's account at 6:30 a.m. and was briefly back in Moscow by 9 a.m. Later that day, he took a thumbs-up selfie in his Pullman apartment, and in the following days, his phone showed searches for University of Idaho murders, a Ted Bundy documentary, and a YouTube video about the victims. By mid-December, Kohberger drove to Pennsylvania with his father, stopped by the Indiana police on December 15th, and the Moscow police sought public help identifying the white Elantra. But DNA from the knife sheath, traced through genetic genealogy, pointed to Bryan Kohberger, and on December 27th, investigators confirmed a DNA match from trash at his family's home, and Kohberger's phone was also showed continued interest in Ted Bundy and a selfie in a black hoodie mirroring Bundy's attire. Now, on December 30th of 2022, Kohberger was arrested at his family's home in Pennsylvania and reportedly suggesting coffee with an officer, unaware of the gravity of the situation. Now, Mr. Kohberger has pled not guilty back in May of 2023 to the 4 counts of first-degree murder and 1 count of burglary. His defense team says there's an alternate suspect and argues against the death penalty, citing his autism. And we know, if you've been following this, we've been bringing it all to you, those motions have been denied. Now, the defense still has a little time to come up with a viable alternate suspect theory, but I think that will fall short based upon what we know thus far. And the trial is scheduled to begin in August of 2025, and we will bring it to you live. There were a couple of other filings also in the matter of Bryan Kohberger the other day. One was a notice by the state saying that it will not call lay witnesses during the penalty phase of the case, instead relying on testimony and evidence from the guilt phase. But the state does intend to allow victims to present victim impact statements during the penalty phase, as guaranteed under the Idaho Constitution, as well as the applicable Idaho statutes that are in place, obviously. And the state requests that immediate family members listed in Exhibit S1 from the February 24th, 2025 motion be permitted to present victim impact statements. Obviously, the family of all the victims would be able to do that. The evidence about the victim impact statements would include the impact of all of the deaths on their family. It's irrelevant and admissible to show the victim's uniqueness and the community's loss. Those statements about the crime, the defendant, or the appropriate sentence are not allowed. The state also notes that it has disclosed a penalty phase expert witness in their January 27th, 2025 discovery response. And then it was also interesting that the court sealed the reply briefs for the prosecution as it related to the mental health evaluation by the state pursuant to the Idaho Code Section 18207, and which I find somewhat interesting because the court already issued the order. I'm surprised that motion was not made public as well. Hey, that's the way it goes. At least we're getting more information than we ever did with the Lori Vallow and Chad Daybell case as well. Next, a quick update on the Karen Reed case. If you've been watching it today, you've been hearing lots and lots of text messages from Karen Reed and from one of her suitors who was trying to work his way in on John O'Keefe. But yesterday, the Karen Reed murder trial continued with the in court there in Dedham, Massachusetts, with significant testimony presented as a part of the prosecution's case against Miss Reed, who is obviously accused of killing her boyfriend, Boston police officer John O'Keefe, back in January of 2022. Quick summary of all the key witnesses. All right. First, Sergeant Yuri Berkenick. Berkenick, assigned to the homicide section of the Norfolk District Attorney's Office, was a key investigator partnered with former lead investigator Michael Proctor during the initial investigation into O'Keefe's deaths. Now, Berkenick described the injuries that he observed on O'Keefe's body, providing details relevant to the prosecution's theory that it was O'Keefe had been struck by Reed's SUV. He testified about his involvement in the investigation, including evidence collection and crime scene analysis. Now, during direct examination by the special prosecutor, Mr. Brennan, Berkenick outlined the steps taken in the early stages of the investigation, emphasizing forensic evidence and the condition of the crime scene at 34 Fairview Road. Now, in cross-examination, Alan Jackson grilled Berkenick on the integrity of the investigation, particularly focusing on his association with Michael Proctor, who was fired for unprofessional conduct, including sending vulgar text messages about Miss Reed. Jackson asked, quote, "Do you think this case was handled with honor and integrity by Michael Proctor?" End quote, to cast doubt, obviously, on the investigation's credibility. The defense sought to highlight potential biases on procedural errors in the investigation, aligning with their narrative of a cover-up. The judge did grant the prosecution's request to bar media from recording the testimony of Mr. O'Keefe's underage niece and nephew, and prohibit everybody from reporting their names as well. As you may recall, O'Keefe was the primary caretaker of these children after their parents' deaths, and their privacy was prioritized. Prosecutor Brennan also presented surveillance footage from C.F. McCarthy's a bar where Reed and O'Keefe were drinking on January 28th on 2022. The footage showed the couple's activities before the incident, potentially to establish Reed's state of mind as well as her level of intoxication. So the testimony focused heavily on the forensic and investigative details, with Berkenick's accounts reinforcing the prosecution's argument that Reed intentionally struck O'Keefe with her Lexus SUV and left him to die in the snow. The defense continued to challenge the reliability of the investigation, leveraging Proctor's disgraced status to suggest some sort of systemic issues in the investigation. And then obviously no testimony from the O'Keefe's nieces and nephews. That was day 12. Day 13 is going on right now. Obviously, this is second trial as well. And you can watch it here, CrimeTalk. Gavel to gavel coverage. Next on the docket, a father was arrested for a Wisconsin school shooter's activities. Remember when the Crumleys were charged in Michigan? And I said, well, here you go. Unique legal theory where we're going to hold people responsible for actions of another. Be careful. It's a slippery slope. Why stop at school shootings? Why not? Hey, if you let somebody that you know maybe had a drinking issue drive your car, why stop there, ladies and gentlemen? Maybe you let somebody watch your children that you shouldn't have. You should have known, after all, right? Be careful what you wish for. I know it makes everybody feel really good when justice is being done, but I'm telling you, ladies and gentlemen, it's a slippery slope, and they will be coming for you as well. So let's get to it. Jeffrey Rupnow, the father of the 15-year-old Abundant Life Christian school shooter Natalie Rupow, was arrested yesterday and charged with felonies related to providing his daughter with the semi-automatic weapons used in the December 16th, 2024 shooting. Now, the attack claimed the lives of teacher Aaron West and freshman Ruby Vergara, and as well as 14 other students were injured. And ultimately, it resulted in Natalie's suicide. Now, this case marks yet another rare instance of a parent being charged in connection to a child's school shooting, highlighting ongoing debates about gun access and parental responsibility. Now, the investigation remains open, with authorities still exploring Natalie's full motives. But though her online discussions about weapons and school shootings have been noted, Rupow faces 2 felony counts of intentionally providing a dangerous weapon to a person under the age of 18, resulting in death, and 1 count of contributing to delinquency of a minor child. According to the criminal complaint, Rupow legally purchased a 9mm Glock handgun for his daughter, which he stored in a gun safe with an access code, his social security number entered backwards, that he shared with Natalie. He also gave her a .22 caliber Sig Sauer pistol as a Christmas gift back in 2023. Now, the acting Madison police chief, John Patterson, stated her father knew that she had them, or at least had access to them, the complaint reveals. And Rupow retrieved Natalie's handgun from the safe for cleaning and was unsure if he returned it. Now, both the Glock and the Sig Sauer were used in the attack, with the investigators recovering 20 shell casings, 3 magazines with .22 ammunition, and a box of 9mm ammunition at the scene. Now, the complaint also provides a little insight into Natalie's life and mindset leading up to the shooting. Now, following her parents' contentious divorce, Natalie struggled with post-traumatic stress disorder and expressed suicidal thoughts, even self-harming, to the extent that her father locked up knives in the home. In a written piece titled War Against Humanity, she described humanity as filth and criticized her father's drinking, stating, "Some of you guys deserve to be dead." Despite her struggles, Jeffrey Rupnow attempted to bond with Natalie through firearms, taking her shooting 2 years prior to the attack. He noted her interest in guns snowballed, as evidenced by a Facebook post from August of 2024 showing Natalie aiming a shotgun at a clay pigeon. Oh my gosh, a shotgun at a clay pigeon? You mean they were out shooting? Oh my goodness. Anyway, court documents reveal Natalie's fascination with school shootings, idolized past shooters as saints, and meticulously planning her attack. She built a cardboard model of the school, scheduled the school shooting to conclude with by 12:10 p.m. and recorded videos handling a semi-automatic firearm. 2 weeks after the shooting, Rupnow messaged detectives expressing regret for teaching Natalie gun safety and urging others to change gun safe combinations frequently, stating, "Kids are smart and they will figure it out." Meanwhile, Natalie's mother, Melissa Rupnow, reportedly reacted to the news of her daughter's action by yelling, "I'm going to kill him," referring to her ex-husband. The shooting left 1 survivor hospitalized nearly 5 months later, and the Madison community continues to grieve. The Madison mayor, Sacha Rhodes Conway, remarked, "What happened at the Abundant Life School should have been impossible." I told you, ladies and gentlemen, I told you. Hey, what happens if your kid drinks because you have some alcohol and they get drunk? Maybe somebody gets sick. Maybe somebody dies. Going to start charging that as well? No. Our fundamental legal system is based upon the person's mens rea. You did something intentionally. You did something recklessly. And occasionally they have negligence, but my position is negligence should not be a criminal offense, right? It goes completely against what we've always done when it comes to criminal law. You had to prove the mental state. Negligence is, well, what would a reasonable person do? Well, that's not a legal standard. That's a civil standard. And they're trying to bootstrap it into these type of cases. Everybody said, oh my gosh, the Crumleys, yes, they need to go to prison, which they did. And maybe somebody will say, that's just wrong. And they'll probably look at it 20, 30 years later and say, well, we felt good about it at the time, but we were probably wrong. We can't go around holding people because where does it stop? Where does it stop? Maybe we should charge the mom for letting dad have access to the child. Maybe we could blame the court for allowing like equal visitation. Maybe the neighbors that came over and said, hey, your kid's a little dark. Maybe not participating. Why didn't the teachers do it? Why didn't the teachers know what's going on? Why didn't they report it to somebody? Where does it stop, ladies and gentlemen? It's ridiculous. Keep it to what the defendant knowingly did. If dad said, here's the guns, today's the big day, then yes, he should be charged. But when the child sneaks in and steals the firearms, and because they figured out the combination to the safe, you should be charged? Are you kidding me? That's ridiculous. I know it's going to make everybody feel good. People are going to say, oh, Scott, if it would save just one life, wouldn't it be worth it? No, because we don't want to compromise our individual freedoms for everybody else. You may, I don't. Next on the docket, a botched execution. So a South Carolina man executed last month by firing squad experienced apparently excruciating conscious pain and suffering for up to a minute before his death due to a massive botch by the shooters who largely missed his heart, according to the inmate's lawyers. Now, the implications of this botched, horrifying situation, writes Michaela Mahdi's legal team, is in a status report and the notice of the botched execution filed with the South Carolina Supreme Court. The filing lists the respondent as the state's former Department of Corrections director, Brian Sterling, who stepped down from his position at the end of April. Now, the document cites a third-party autopsy report commissioned by the South Carolina Department of Correction that shows several alleged mistakes committed by the department shooters during the April 11th execution, including their low placement of shots. According to the attorneys, the shooters fired 2 shots instead of 3 as required, and their actions ultimately led to the suffering of Mr. Mahdi's execution. One of the pathologists from the autopsy, a Dr. Jonathan Arden, reported that Mahdi's appears to have 2 half-inch wounds that were just above the border of the abdomen, which is not the area largely overlying the heart, according to the notice. The autopsy also documents 2 distinct wound paths that travel downward and to the right inside of Mr. Mahdi's torso, going into the left lobe of the liver and the pancreas and the left lower lung lobe before crashing into his spine and ribs. Now, along the way, the bullet fragments made 2 perforations of the right ventricle of Mr. Mahdi's heart, comprising 2 holes in the front and 2 holes in the back, leaving it otherwise intact. Mr. Mahdi has been on death row since 2004 for a multi-state crime spree, which included 3 alleged murders, 2 of which he was tried and found guilty. Now, his attorney said, as his advocates and as officers of the court, we feel obligated to share this information with you and the others who represent condemned prisoners who will face the same dilemma. Mr. Mahdi elected the firing squad, and this court sanctioned it based on the assumption that the South Carolina Department of Corrections would be entrusted to carry it out with the straightforward steps of locating the heart, placing a target over it, and hitting the target. That confidence was clearly misplaced. Now, you may remember this. We brought you the case when it came out, the United States Supreme Court case of Bucklew v. Pressis, which is a 2019 case. And the key quote from that majority opinion written by Justice Neil Gorsuch addressed the issue of whether the Eighth Amendment guarantees a painless execution. The court wrote, quote, "The Eighth Amendment does not guarantee a prisoner a painless death, something that, of course, isn't guaranteed to many people, including most victims of capital crimes. Instead, what unites the punishment the Eighth Amendment prohibits is that they are cruel and unusual, meaning they involve the super addition of terror, pain, or disgrace, or are otherwise grossly disproportionate to the severity of the crime." So the court held that the Eighth Amendment does not require the state to adopt an alternative method of execution unless the inmate shows that the challenging method entails feasible and readily implemented alternatives that would significantly reduce a substantial risk of severe pain. I get it. It was an execution. Some people are for him. Some people are against him. You would hope, though, that the South Carolina Department of Corrections could have got 3 of their best shots and got a really good scope and hit their target. But clearly they failed miserably. But in this particular case, Mr. Maddie, his rights were not violated. We'll see what the South Carolina Supreme Court does in this particular case. Next, a Texas realtor gunned down, a classic example of let it go. Because now we have dead people and other people having their lives completely turned up. It's just stuff. Anyway, a tragic shooting in downtown Dallas on April 5th claimed the life of Ashley Long. She was a Texas realtor attending a work conference after a minor interaction with a car escalated into a deadly confrontation. Now, the incident, captured on video, has led to legal proceedings and conflicting narratives about who bears responsibility for the violence. Well, this all took place about 2:30 a.m. on April 5th. Long and her friend William Chrysler were in downtown Dallas when Chrysler inadvertently brushed up against a white Mercedes-Benz driven by Kendrick Finch. The contact prompted Finch to stop his car, exit the vehicle armed with a 9mm handgun. And according to the police reports and surveillance footage, Chrysler reached into Long's purse to retrieve his .40 caliber pistol, struggling with Long as she attempted to restrain him. As the situation escalated, Finch opened fire on the busy street, lined with shops, restaurant, and apartment buildings, striking Long fatally. Chrysler, who managed to fire 3 shots from his weapon, was also wounded and hospitalized. Now, Finch fled the scene but was contacted by police hours later, identifying himself as the shooter, and he surrendered to the police on April 18th. Now, Finch, whose prior criminal record includes charges for drugs and burglary charges, now faces charges related to the shooting. His attorney argues that Chrysler instigated the violence, asserting that Ashley Long would be alive today except for William Chrysler's actions. William Chrysler is the one who started everything that night, the attorney says, and it shows that on the video. The lawyer suggested that Chrysler's behavior, potentially influenced by substances pending toxicology results, provoked the incident by approaching Finch's car quite aggressively. The defense further claims that Finch acted in self-defense, stating, "When Chrysler takes those steps towards my client has every right under the law to defend himself." The prosecution has not yet released a toxicology report, and the case remains under investigation. Now, Long's family, devastated by the death, declined to speak to the media following the court appearance on May 8th. And previously, Ashley's mother, Michelle Long, said she's still in a fog. She feels like I'm in a daze. The family described Ashley as a vibrant young woman who was simply in the wrong place at the wrong time. Obviously, this shooting, like many others, has raised concerns about gun violence not only in Dallas but across the country, particularly in downtown areas. Like I said, this incident, sparked by a seemingly trivial encounter, underscores the rapid escalation possible in confrontations when somebody has a firearm. As the legal process unfolds, the focus is going to remain on who is going to be accountable for Miss Long's death. Let it go, ladies and gentlemen, because you never know. Now here, both people had firearms, 2 that were firing. The innocent victim did not. But the reality of it is that you just never know. I've always said that road rage incident, somebody cuts you off, let it go. Because you don't know if that person has a gun in there. And all it takes is that knucklehead having one lucky shot that could end your life or somebody else's in your car, and let alone on a street today. Contact the cops, for goodness sakes. Let it go. Next, a unique manner of shooting somebody. This story comes from Bentonville, Arkansas. A 29-year-old Rogers, Arkansas man, a guy by the name of Joseph Michael Alexander, faces attempted capital murder and other charges after allegedly shooting his mother, Mary Alexander, multiple times with a crossbow in their home back in March of this year. Now, the incident, reportedly triggered by a comment about a cat, culminated in a high-speed chase and Alexander's arrest in Missouri. Now, according to the probable cause affidavit, the incident began about 6:45 a.m. when Mary Alexander awoke to let a meowing cat outside. Moments later, she felt a sharp pain, later described as her eardrum. It felt like her eardrum had popped, and saw blue. Now, her husband, Mike Alexander, found their son standing over her with a crossbow with multiple arrows lodged in her head. Joseph Alexander allegedly forced his way into the bedroom, seized their phones, and demanded money. extorting $2,000 of cash via Cash App and $1,400 in Bitcoin. Now, when his parents couldn't provide bank access, he reportedly threatened to go to the next level and told his father, "Don't worry about it, Dad. She's dead." Anyway, Mary Alexander, severely injured, played dead to survive. She overheard the son say he wouldn't kill his father to avoid a double homicide charge. But after Joseph fled the house in the father's white Toyota Tacoma, Mary used her walker to reach the neighbor's house. At approximately 8:08 a.m., a neighbor called 911, reporting that she had been shot in the face. First responders found her with arrows in her face and her head, and obviously rushed her to the hospital where she received treatment for these injuries. Later that day, Stone County, Missouri deputies spotted the stolen truck and attempted to stop Mr. Alexander. He then led them on a high-speed chase, which ended in a crash. Now, after resisting arrest and being tased, Alexander was taken into custody. Paramedics reportedly said that he confessed to shooting his mother, claiming he used a toy crossbow after she made a comment about his cat that enraged him. He allegedly shot her once, and when she screamed, fired once and then fired 2 more times. In a recorded interview with the Bentonville police, Detective Jason Beeler, who conducted it, stated that Alexander admitted to breaking into his parents' home through his old bedroom window to avoid waking them. When pressed for a motive, he said, "I didn't have a reason. I just lost my cool. I thought she was like going after my cat." In a striking exchange with the detective, "So you shot your mom in the head 3 times because of your cat?" Alexander replied, "Yeah, like that is the best process I understand of what happened." Alexander faces charges of attempted capital murder, aggravated residential burglary, first-degree interference with emergency communications, and third-degree domestic battery, currently being held in the Benton County Jail on a $750,000 cash-only bond. His next court appearance is June 9th. What can you do? What can you do, ladies and gentlemen? You can't make this stuff up. You just can't make this stuff up. Next, Lori Vallow. So, as you know, she was convicted, and she's got yet another trial, but she was convicted of conspiracy of committing her husband, Charles Vallow, and then she filed a motion for a new trial. Well, the prosecution has responded. So Lori Vallow filed a motion for a new trial in Arizona following her April 25th conviction for conspiracy to commit murder of her 4th husband, Charles Vallow. Now, the prosecution and defense presented detailed arguments addressing the motion, which centered on several key issues. Lori Vallow's arguments for a new trial include, and remember, she's appearing pro se on this, first, jury misconduct. Vallow claims that the alleged juror number 15 was aware of her prior Idaho convictions for the murders of her children, Tylee Ryan and JJ Vallow, and the conspiracy in the death of Tammy Daybell. She argues that this knowledge, not presented as evidence in the Arizona trial, prejudiced the jurors' impartiality. Now, the claim stemmed from the interview with Juror 15 conducted by Hidden True Crime, which Vallow cited as evidence of the jurors' exposure to the extraneous information. She says that this compromised the fairness of the trial. She also says that there should have been a preclusion of statements by Tylee Ryan and Alex Cox. Vallow argued that the court improperly excluded statements made to police by her daughter, Tylee Ryan, and her brother, Alex Cox, who shot Charles Vallow. She contended these statements were critical to her defense as they supported her claim that Cox acted in self-defense. Specifically, Vallow asserted that the statements from Cox and Tylee were made during police interviews following the July 19th shooting shaped the initial police response, which treated the incident as self-defense. She argued the excluding these statements prevented her from presenting a complete defense. Well, Ms. Vallow, as you know, as a lawyer and all, those statements were testimonial in nature, and they're not admissible when the individual cannot appear in court and be subject to cross-examination. You probably knew that already, though, Lori, because you're like a lawyer and all. Anyway, there's also an allegation of a discovery violation where Vallow alleged that the prosecution failed to disclose evidence in a timely manner, violating the discovery rules and hindering her ability to prepare an adequate defense. Specifically, the nature of the alleged violation is not detailed but Vallow claimed it impacted her trial preparation and fairness. Now, she also claims prosecutorial misconduct. She accused the prosecution of engaging in misconduct though the exact nature of the alleged misconduct was not fully specified in her motions. The claim is likely related, though, to her broader assertion that the prosecution's actions, possibly including their handling of evidence or statements during the trial, were improper and prejudiced the outcome of the trial. She also said the court lacks impartiality. That's right. Vallow says that the trial judge who presided over her case lacked impartiality, which affected the fairness of the proceedings. Once again, she did not provide specifics on the bias in the motion, but the claim suggests that the judicial rulings conducted during the trial favored the prosecution. Welcome to criminal defense, Lori Vallow. Welcome to criminal defense. Now, the prosecution filed a response to all of these allegations, and needless to say, they say first, there is no juror misconduct. The prosecution refuted the claim of juror misconduct by citing an interview with Juror 15 conducted by Hidden True Crime, which clarified that the juror only learned of Vallow Daybell's Idaho convictions after the Arizona trial verdict was delivered and the jury was released. They emphasized that the juror was required to sign daily declarations confirming that they had not been exposed to improper or prejudicial information as per court instructions. The prosecution argued that no evidence supported Vallow's claim that juror 15 had knowledge of that information during the juror deliberations. The prosecution also maintained that the court's decision to exclude statements by Tylee Ryan and Alex Cox was legally sound and did not prejudice Vallow's defense in any way whatsoever. And they basically argued that since Vallow could not benefit from statements by witnesses she was convicted of killing, the prosecution notes that Cox's interview at the scene of the shooting was admitted, but Tylee's statements were excluded as irrelevant or prejudicial, a ruling they defended as appropriate. And once again, the prosecution says, deny any discovery violations, asserting that they have complied with all obligations to disclose evidence to Ms. Vallow in a timely manner. Needless to say, the prosecution also says there was no prosecutorial misconduct. They rejected that accusation, arguing that their conduct throughout the trial was professional and adhered to the legal and ethical standards that they are bound to abide by. As it relates to judicial impartiality, the prosecution defended the court's impartiality, asserting that the judge conducted the trial fairly and made rulings based upon legal merits. Of course, they think so because they won, but I get it. The judge, I thought, did a very good job throughout the trial in that particular case. Anyway, those are the allegations. Those are responses. The judge will have to rule on the motions, but you can expect the motion for a new trial will be denied. All right. It's that simple. No judge is going to admit that they made a mistake at the trial level that resulted in an unfair trial and to do a do-over. Simply not going to happen. That's what appellate courts are for, right? And then next on the docket, former United States Supreme Court Justice David Souter passed away yesterday. Now, obviously, he was a jurist who served as an associate justice on the United States Supreme Court from 1990 until his retirement in 2009. He was born in Massachusetts, and he grew up in New Hampshire and maintained a deep connection to his home throughout his life. He graduated magna cum laude from Harvard College in 1961 with a degree in philosophy, attended Oxford University as a Rhodes Scholar, and earned a law degree from Harvard in 1966. After a brief stint in private practice, Souter began a long career in public service, starting as an assistant attorney general in New Hampshire. He later served as the state attorneys general, an associate justice of the New Hampshire Superior Court, and an associate justice of the New Hampshire Supreme Court. In 1990, President George H.W. Bush appointed him to the U.S. Court of Appeals for the First Circuit, and later that year to the Supreme Court, replacing Justice William Brennan, known as the stealth nominee due to the limited paper trail Souter had Souter was expected to be considered a conservative justice, but emerged as a moderate, often aligning with the court's liberal wing on key issues. Now, after retiring in 2009, he returned to New Hampshire, continued hearing cases on the First Circuit, and advocated for civics education. Souter, a lifelong bachelor known for his frugal and private lifestyle, died at his home at the age of 85. The other significant case that Souter wrote was Roth Jerry v. Gillespie, where Souter's majority opinion clarified that the Sixth Amendment right to counsel attaches at a defendant's initial appearance before a magistrate, where charges are presented and liberty is restricted, ensuring early access to legal representation. Then in Brendlin v. California in 2007, Souter authored the unanimous opinion ruling that a passenger in a vehicle subjected to a traffic stop is seized under the Fourth Amendment and can challenge the stop's constitutionality, extending protections against unreasonable searches and seizures. Then in 2001, there was Atwater v. Lago Vista, where Mr. Souter wrote for the majority opinion, and it held that the Fourth Amendment does not prohibit warrantless searches for minor offenses such as a seatbelt violation, affirming police discretion in such cases, but sparks debate over potential abuses. Now, Souter's criminal law opinions often demonstrated a nuanced approach to protecting individual rights while acknowledging practical law enforcement needs. His broader legacy includes influential votes in cases like Planned Parenthood v. Casey, where he helped preserve abortion rights, and dissents in cases like Bush v. Gore, reflecting his commitment to judicial integrity. Next on the docket, this day in legal history. May 9th, 1865, President Johnson declares the end of the armed rebellion. That's right, Andrew Johnson issued a proclamation declaring the armed rebellion of the Confederacy was effectively over. This led to legal measures for Reconstruction, including amnesty and treason trials. On this date in 1933, they had the Emergency Banking Act fallout. That's right. Investigations into bank fraud intensified following the Emergency Banking Act of March of 1933. Prosecutions of bankers for mismanagement shaped the New Deal financial reforms that followed. On this date in 1941, the FBI targets Nazi sympathizers. That's right. The FBI arrested members of the German-American Bund in New York for subversive activities. These cases tested wartime sedition laws and expanded federal surveillance powers. On this date in 1969, the Chicago 7 trial preparations begin. That's right. The prosecutors were finalizing charges against the Chicago 7 for inciting riots in the 1968 Democratic National Convention. The trial raised First Amendment and protest rights issues. On this date in 1974, the Nixon impeachment hearing begins. That's right. On May 9th, the House Judiciary Committee opened impeachment hearings against President Richard Nixon for the Watergate-related crime, marking a historic legal challenge to the executive power. And on this date, May 9th, 2001, Robert Hansen was indicted for espionage. He was a FBI agent and was indicted for selling secrets to the Soviet Union and Russia. His case prompted reforms in FBI counterintelligence and espionage laws. And finally, our dumb criminal of the day. In the sultry haze of a Florida night, where the air is thick and the nachos are thicker, a Port St. Lucie kitchen became the stage for a domestic drama that equals part absurd and mad as well. At 3 a.m., where most folks are dreaming of tacos or scrolling X, no, Allison Swan, a 39-year-old nurse, allegedly turned her wife's midnight snack into a crime scene, straight out of a B movie. The victim was a registered nurse and a nacho enthusiast, and apparently is whipping up a plate of gooey, cheesy, drenched nachos in their home. Enter Swan, fresh from a marathon gaming session in the living room, who decided to weigh in on her spouse's late-night culinary choices. "You shouldn't be eating this late," she reportedly sneered, tossing in a jab about her wife's weight for good measure. Harsh, but not yet a felony. What followed, according to the police reports, was a nacho-fueled escalation that would make even Gordon Ramsay blush. Swan, apparently unimpressed by the sanctity of the snack time, stormed over, grabbed a fistful of those sacred cheesy chips, and shoved them down the back of her wife's leggings. Yes, you heard that correctly. Nacho cheese shoved down the spandex. The culinary crime didn't stop there. When the victim tried to change out her new dairy-drenched attire, Swan allegedly dragged her to the floor, hooked his fingers into his wife's mouth like a fisherman's reel in a catch, and slammed her head into the floor multiple times. All the while Swan's wife declared herself the alpha, insisting his wife was not behaving. Because nothing says I'm in charge like turning your spouse into a nacho-stuffed piñata. The chaos was overheard via an open phone line by a friend who promptly called 911. The Port St. Lucie police arrived. They found the scene that couldn't be described as a nacho nightmare. The victim's leggings bore the smears of nacho cheese on the backside, perfectly corroborating her story. A wall was splattered with what looked like the remnants of a Nacho Jackson Pollock painting, and the victim sported a knot on her forehead and a scratch on her arm. Battle scars from the Great Nacho War, apparently. Meanwhile, the ceramic plate that allegedly held the nachos completely intact, debunking Swan's claim that her wife, in a drunken rage, had hurled it and rolled around in a cheese-like nacho-coated performance artist. Swan, for her part, denied any physical altercation, painting herself as the calm gamer caught in her wife's throwing tantrum. But the evidence was undeniable as the smell of queso on a hot summer's night. She was arrested for misdemeanor domestic battery, booked into the county jail, and released on a $250 bond. The court orders now bars her from contacting the victim or going near her car or workplace or home. Since they live together, Swan gets a police escort trip to grab her stuff, presumably some more nachos. Anyway, the cheesy caper leaves us one burning question. Who knew that nachos, the ultimate comfort food, could spark such a meltdown? In the annals of domestic abuse and food violence, this one is going to stand out, proving that love may conquer all, but nacho cheese conquers common sense. Here, hoping that these two nurses patch things up, at least they can keep the snacks out of the spandex, I guess. All right. There you have it, ladies and gentlemen. Once again, you just can't make this stuff up. That's all we have for today. Thanks for watching. Have a wonderful weekend. We'll see you next time on Crime Talk. And remember, the Constitution matters.